Be ready. Start. It is a well recognized principle of criminal jurisprudence that anyone can set or put the criminal law into motion except where the statute enacting or creating an offense indicates to the contrary. The scheme of the Code of Criminal Procedure envisages two parallel and independent agencies for taking criminal offences to court. Even for the most serious offense of murder, it was not disputed that a private complaint can not only be filed but can be entertained and proceeded with according to law. Locus standi of the complainant is a concept foreign to criminal jurisprudence, save and except that where the statute creating an offense provides for the eligibility of the complainant, by necessary implication, the general principle gets excluded by such statutory provision. Numerous statutory provisions can be referred to in support of this legal position, such as 1. Section 187A of C Customs Act 1878, 2. Section 97 of Gold Control Act 1968, 3. Section 6 of Import and Export Control Act 1947, 4. Section 271 and Section 279 of the Income Tax Act 1961, 5. Section 61 of the Foreign Exchange Regulation Act 1973, 6. Section 621 of the Companies Act 1956, and 7. Section 77 of the Electricity Supply Act. This list is only illustrative and not exhaustive. While Section 190 of the Code of Criminal Procedure permits anyone to approach the magistrate with a complaint, it does not prescribe any qualification the complainant is required to fulfill to be eligible to file a complaint. But where an eligibility criteria for a complainant is contemplated, specific provisions have been made, such as to be found in sections 195 to 199 of the CRPC. These specific provisions clearly indicate that in the absence of any such statutory provision, a locus standi of a complainant is a concept foreign to criminal jurisprudence. In other words, the principle that anyone can set or put the criminal law in motion remains intact unless contradicted by a statutory provision. This general principle of nearly universal application is founded on a policy that an offense, that is, an act or omission made punishable by any law for the time being in force, is not merely an offense committed relation to the person who suffers harm, but is also an offense against society. The society, for its orderly and peaceful development, is interested in the punishment of the offender. Therefore, prosecution for serious offenses is undertaken in the name of the state representing the people, which would exclude any element of private vendetta or vengeance. If such is the public policy underlying penal statutes, who brings an act or omission made punishable by law to the notice of the authority competent to deal with it is immaterial and irrelevant unless the statute indicates to the contrary. Punishment of the offender in the interest of the society being one of the objects behind penal statutes enacted for larger good of the society, right to initiate proceedings cannot be whittled down, circumscribed, or fettered by putting it into a straight-jacket formula of locus standi unknown to criminal jurisprudence, save and except specific statutory exception. to hold that such an exception exists that a private complaint for offences of corruption committed by public servant is not maintainable, the court would require an ambiguous statutory provision and a tangled web of argument for drawing a far-fetched implication cannot be a substitute for an express statutory provision. In the matter of initiation of proceeding before a special judge under section 8(1), the legislature, while conferring power to take cognizance, had three opportunities to unambiguously state its mind whether the cognizance can be taken on a private complaint or not. The first one was an opportunity to provide in section 8(1) itself by merely stating that the special judge may take cognizance of an offence on a police report submitted to it by an investigating officer conducting investigation as contemplated by section 5A, while providing for investigation by designated police officer of superior rank. The legislature did not fetter the power of special judge to take cognizance in a manner otherwise than on police report. The second opportunity was when by section 8(3) a status of a deemed public prosecutor was conferred on a private complainant if he chooses to conduct the prosecution. The legislature, being aware of a provision like the one contained in section 225 of the CRPC, could have as well provided that in every trial before a special judge, the prosecution shall be conducted by a public prosecutor, though that itself would not have been decisive of the matter. And the third opportunity was when the legislature prescribed for warrant cases. Thank you.